So one thing that needs to be kept in mind is that if you do believe that there's a question as to the genetic relationship between you and a child, that challenge must be brought within 4 years. Otherwise, the presumption is irrefutable. And that allegation, and despite genetic testing, cannot be undone according to state law. So let's assume, worst case scenario, there's a marriage, there's an extramarital relationship between the wife and someone else. She is impregnated, a child is born. 4 years later, 5 years later, after the birth of that child, there's a genetic test that establishes no genetic relationship between husband and presumed father and the child, meaning it's too late, and even though that child is not genetically related to the husband/father, who's probably in the middle of a divorce, that presumption of fatherhood is going to hold for the next 15 years until that, or however 13 years until that child reaches the age of 18. So there is a time limit on when that challenge must be made, and it's essential, just like you've heard me say in other video series, know when your statutes of limitations are and don't sit on your rights. Being proactive is always your friend in these kind of scenarios. So there's a number of scenarios that I've discussed regarding the presumption of parenthood, fatherhood in Texas, as prescribed by our Texas legislature. And again, I'm stressing this because it comes up more and more often, and the legislature passed these laws. The judge has no discretion except to enforce them. So if there's a question, you need to challenge, you need to bring the appropriate challenge, a motion to determine paternity, compel genetic testing, and you need to do that within 1 to 4 years, but less than 4 years after the birth of a child. And the reason why is because after the 4th birthday, the presumption is not challengeable, and therefore, if you determine that later, year 5, you do a genetic test, you find out that there's no genetic relationship between father and child, still on the hook for 25% of child support, and then about 9% for medical support on top of that. So it's not a law that it's reasonable. It's not fair. And fair is what you get in Dallas in the fall. What you get from the legislature in Austin is reasonable. This is a reasonable protection to keep as many children as possible, basically off the public dime, not on social welfare, because there's the presumption that if a child was born during a marriage or within 301 days of an end of a marriage, or if a father's on a birth certificate, something to that effect, there's a presumption, and it has to be rebutted pretty quickly. So like I've said with everything else, don't sleep on your rights, be proactive. Being proactive is your friend. Playing ostrich, burying your head in the sand, trying to make a problem go away is usually to your detriment. And these are things that can be challenged, and if they need to be, they should be, because it shouldn't be someone else's obligation to financially provide for a child who's not theirs. And if there's a question about it, you need to take action quickly. Remember, within 1 to 4 years, but no later than 4. So I hope this has been some help. If you have any questions or comments, please leave them below. I'd love to respond to them. Thanks for watching. Have a wonderful day.